Welcome to the No Show. This is not a show. I am not your host, Alex Winston, and this is not my guest, Christy Rogers. Christy is a shareholder at Maynard Nexsen. Christy works in Maynard Nexsen's Columbia, South Carolina office, where she focuses on employment law. She also had the distinct pleasure of attending law school with me more years ago than I care to mention. Christy, thank you for showing up. How are you?
I'm good, Alex. How are you?
I'm doing great. It's been a long time. It's good to see you again. Glad to be able to get an employment lawyer on to discuss some topics that have really been a buzz in our community, in the logistics community recently. So, you're an employment lawyer. In my experience, employment lawyers fall into two categories. They either mostly work with employees or they mostly work with employers. Which one are you?
Right. That's an accurate assessment there. Yeah. So I do employer side of things in the employment world. So I work with companies and advise them on employment and labor related issues. So exclusively employer side.
Okay, got it. So the employers who are listening should know that Christy is one of the good ones, and in the, and the employees who are listening should know that Christy is the devil. But Christy, there are countless practice areas in law. What drew you to employment law?
Well, I like to tell people, the cool thing about employment law is that, I'm the lawyer of drugs, sex, and rock and roll, right? I think that, employment is a very small kind of niche area of the law, but it's really interesting. And I think one of the things that kind of drew me to this area is that I enjoy the litigation aspects of the law and what I do, but I really enjoy the counsel and advice portion of my practice as well. So it's really about advising employers, training managers, trying to help companies do the right thing, make the right decisions, stay within the bounds of the law. And I really like that because I think that it fosters a good long-term relationship between a lawyer and a client. I think in a lot of other areas of law, you kind of only see clients for a short period of time when, everything has hit the fan, right? When they're in a really bad situation. And the great thing about employment law is that I kind of grow and progress with my clients. The life of a client relationship is much longer and can last years and years because I continually provide counsel and advice to my clients on employment related issues. So I really like that aspect of it.
Good. Before I ask you any questions about the law, I do want to have a little disclaimer for both of our benefits, since I'm technically still a licensed lawyer as well. I don't practice law, but nothing said here is legal advice. No one should rely on anything we say whatsoever. Christy and I are here to inform, hopefully to entertain as well, but we're not giving legal advice. If you want legal advice on a particular matter, I would tell you go find a licensed attorney where you live. And if that happens to be South Carolina, I cannot recommend Christy Rogers enough. Go talk to Christy Rogers or someone else at Maynard Nexsen, and you guys are all over the country, aren't you?
Yeah, we are. We recently merged we were Nexsen Pruitt, and we recently merged with another law firm in Alabama called Maynard Cooper. So we're now Maynard Nexsen. So we are everywhere.
Okay. Yes. I remembered Nexsen Pruitt from my law school days, but now that explains the name change. I get it now. Okay. Good. So let's get into it. Some big topics to talk about in employment law recently. A lot of people in my industry, logistics, are talking about these issues. And the big one is the FTC recently announced a rule that is being widely described as a ban on non-competes. I've seen a lot of confusion about this one. I've heard people say, hey, you can go after any customer you want to now because of this ban, right? You can do whatever you want. There is no restrictions on competition at all. You can do anything. They seem to think it's no more non-solicits, no more NDAs, no more anything, and they're gung-ho about it right away. First of all, Christy, is the FTC banning all non-competes?
Yeah, so the answer to that is yes, sort of. It's kind of like that famous law school answer, it depends, right? Mm-hmm. So yes, sort of means that yes, for the most part, most non-compete provisions, if this rule actually goes into effect, right? And that's, I know, something we'll talk about in a minute. There's a bunch of legal challenges, and it's kind of up in the air whether or not this is even going to become, official law. But assuming that it does, then it would ban all non-compete agreements with a couple of exceptions. One of those exceptions would be obviously industries or areas where the FTC does not have authority, right? So, for example, nonprofit organizations are not covered by the FTC. Some banking institutions, international air carriers. There's a couple of small exceptions that would not be covered by this new rule. Another example would be non-compete agreements with senior executives. And so if there is a company that has an existing non-compete agreement with a senior executive, and that's specifically defined under the rule as someone who has policy-making authority and makes a certain salary, it's like almost $152,000 a year. It's like $151,000 and what is it, 151, 162 or something like that. It's, they can't just give us a round number. They've got to make it complicated. But those senior executives would be individuals who, if they already have an existing non-compete agreement at the time the rule becomes effective, those agreements would still be enforceable, as well as agreements, obviously, like I said, for industries over which the FTC does not have any regulatory control. So for the most part, the answer is yes, it bans non-compete agreements. But I think you're right. I think there's some confusion and even some panic in some instances about what constitutes a non-compete provision. A non-compete is not the same thing as a non-solicit or a non-disclosure agreement, or certainly shouldn't be. However, the FTC has taken a very expansive view of what a non-compete is, which means if you have a non-solicitation provision in an agreement that says non-solicit but acts as a non-compete, that would be considered unlawful under this new rule. Okay, so an example would be, typically when we think about non-solicitation, usually what we're talking about is a situation where a company says, hey, when you leave our employment, we want you to be sure that you do not solicit our customers, you don't solicit our clients, because obviously that's what we have a legitimate business interest in preserving, right? That's where the majority of our revenue comes from, are these client contacts and these business contacts, that we've made with these individuals with whom we do business. And so a non-solicit usually just says you as the employee agree not to solicit our customers or clients for business. You agree not to try to convince them to stop using our company and start using another company. But sometimes when these non-solicit provisions are drafted, they're drafted very broadly, such that it not only prohibits an employee from soliciting business from a customer or client, but it also prohibits that employee from taking employment with a customer or client, right? So that would be an example where under the FTC's rule, we might say, well, this is a more expansive non-solicitation provision that acts as a non-compete.
Got it. Okay. So, Christy, is the FTC's proposed ban on non-competes retroactive? Is it going to apply to agreements that already exist, or is it just go forward agreements? Clear this up for people.
Yeah, so it's actually a retroactive application. And there are some specific provisions in the rule that require employers to provide notice to employees who are currently under a non-compete that their non-compete is no longer valid. So let's say, for example, we have a non-compete provision that prohibits people from competing with our business for 2 years after they leave our employment. We may have to go back as many as 2 years and figure out what employees work for us, what employees have left our company that would still be under a non-compete provision, and provide notice to them. So this is not just a matter of any new non-competes we enter into are now considered unenforceable. It's a matter of it's all non-competes, whether we enter into those now or we entered into those a year ago. It is retroactive application.
So the rule is going to require that an employer who has former employees that are still subject to non-competes to try to reach them however they might, right? To let them know, hey, your non-compete provision is no longer enforceable or is
Yeah,
no longer
that's
in
right. And
effect.
there's actually
right?
the rule itself
Okay.
actually has kind of like some sample form language that they would recommend that employers use to send out to employees. But as you can imagine, if you're a really big operation and you've got a whole lot of people who've come and gone in a year or two period, depending on the length of your non-compete, providing notice to all these people is going to be no small task, and tracking them down. Yeah.
Yeah. Yeah, I would imagine that would be difficult for some.
Right.
People move, people may not, you may have their personal email address, you may have their correct phone number, but I guess there's going to be probably some sort of reasonable standard like lawyers like to have, right? Did you do what you should have done? What a reasonably prudent employer would have done to try to
Right. I mean,
notify
there's
this
stuff about,
person,
a
right?
last known address, an email address, a telephone number, a mailing address, all kinds of different ways that an employer is obligated to try to reach out to these folks to let them know, hey,
Yeah.
your non-compete is no longer valid.
Yeah. So it's like good faith effort. You don't have to go hire a private
We hope
investigator to
not.
hunt this, right?
Not according to the rule. Let's
Yeah.
Let's hope it doesn't come to that.
All right. So non-competes, I haven't done much employment law, fortunately, right? But my understanding, it's always been sort of a state law issue. All of these restrictive covenants, right? Non-competes, non-solicits, NDAs. A state court has probably made rules. Sometimes a state legislature has made rules about these things. And now there's this federal FTC rule. Is that going to supersede whatever a state says about
So the way
non-competes?
this works is that the answer to that is yes, unless the state law has further restrictions. So let me give you an example. As I said before, technically under this new rule, non-solicitation provisions and non-solicitation agreements, as long as they don't act as non-compete agreements, are still enforceable and lawful under the FTC's ban. However, in a state like California, which is one of our kind of wonky bugaboo states when it comes to employment stuff, they have a law that bans non-solicitation agreements for customers and clients. So in that situation, all non-competes would be banned under the FTC rule, but under California law, there would still be a ban on the non-solicit agreements. But yes, it would supersede and preempt state law.
Do you have a prediction? I'm not going to hold you to it, but do you have a prediction on where this thing might end up? I know we have a Supreme Court that people say is pretty conservative. Everyone's talking about what I call the political question. And the political question is this a good rule? And to me, that's probably less relevant to the courts than, is the FTC allowed to do this? Which is, I think, is what the courts are going to answer. They can't look at, hey, is the rule good or bad, right? At least we hope that's not what they're looking at. What they're looking at is, does the FTC have the legal authority to do this? And so that's going to be the question that perhaps the U.S. Supreme Court may ultimately answer. How do you think that gets answered in the end? Do you think that they're going to uphold this rule, or do you think they're going to say, hey, go back to the drawing board, we're not going to let this go
I think
through
you're right.
way?
I think, look, the big issue is going to be, has the FTC exceeded their authority in issuing this rule, right? And it's kind of like you said a few minutes ago. I mean, this issue has always been one that has been left to the states, which I think further kind of supports the argument that the FTC has sort of exceeded their bounds here, without getting too much into the constitutional weeds on the issue, right? The issue becomes, under the Constitution, under the FTC Act, which grants the FTC authority to, regulate issues and kind of, deal with issues involving unfair competition, does that really encompass these non-competes, right? And so I think part of it becomes, did Congress really delegate this authority to the FTC? Did Congress have the constitutional right and ability to delegate this authority to the FTC? And so I think part of it also, if we kind of dig a little bit deeper, the issue will be when we talk about the FTC being empowered to regulate unfair competition, what does that mean? Are we talking about just unfair competition as it relates to between businesses? or are we talking about unfair competition, as it relates to employment? And those are two very different things. And so I think that there may be certainly, some pushback and some feeling that, they've gone too far here. And I honestly, I think that's probably where either a lower court will land, and it either won't be, it's possible it will not be appealed up to the Supreme Court. With the current administration coming in, if the administration changes, they may not want to. If the Biden administration stays in power, they may decide they would much rather have an unfavorable ruling from a circuit court rather than the Supreme Court. There's any number of ways this can play out. But I think when we look at this, to me, the issue of whether or not it passes is significant. But I think even on a broader scale, what is really going on here is this changing mindset and this changing perception about the use of non-compete provisions in the employment context. And I think that what we're starting to see is that we're getting more bipartisan support for this idea that non-competes as they are currently used in the market is not sustainable. So does this mean that Congress will now circle back around and they will implement a law that, restricts the use of non-competes in some way? Obviously, that remains to be seen. But I think that at the very least, if this rule is stricken down, it could certainly be the catalyst for some other lawmaking to go on, either on a state level or even on a federal level, where Congress comes in and says, we're now going to actually pass legislation that deals with this issue specifically.
Yeah, and I think that's a really good analysis. I think ultimately, right or wrong, I'm not going to argue the political question, because that's for people to argue about, right? I think what the law looks at is, can the FTC do this? And I think where the courts will come down is they'll say, they'll use the major questions doctrine, and they'll say, this is a major question. Right? Issue has been around for hundreds of years. And if Congress wanted to do something about it, they would not have been subtle about it, right? They would have done something expressly and said, hey, we're banning this non-competition stuff for employees. They would not have, had it implied in some language about unfair competition. So I think that's where they come down. Again, it's not a political statement. It's just, this is what I think the courts will look at and how they'll apply the law as it exists right now. And so ultimately, if that is what happens, and you want to see it change, you got to get involved politically and get that changed from a legislative standpoint.
And I do think it's becoming more cognizant of the fact that, some of these agreements may make it harder for individuals to move around, to gain other employment, and I think a lot of companies that are smart about non-competes and have good employment lawyers know that, you don't need to have a non-compete agreement for every single person in your company. Telling a janitor they can't go to another company and provide janitorial services, you probably don't have a legitimate business interest in doing that. So I think that, there are a lot of companies that are already doing the right thing in terms of, how they implement and use these non-compete agreements and being selective about the employees that they ask to sign these agreements. But I think the concern is that there are some that are still using it as a kind of a broad ban, a way to prohibit folks from freely moving between jobs. And when you're looking at people who are lower wage workers, who are more likely to be living paycheck to paycheck, that creates a problem for them to be under these non-compete agreements and be in a situation where they really can't afford to leave their job because they can't get another job due to these non-compete provisions.
Yeah, I think it's selective about who you have sign it if you're going to have non-competes in your business, right? And then also when you're going to enforce it, right? You've got to choose your battles. And, not everybody who goes to a competitor is worth filing a lawsuit over, in my opinion, right? If you have these agreements in place. And so, but again, that's something for, your clients to talk to you about, right? And if I'm an employer, for me to talk to my attorney about, hey, I've got this non-compete provision. Here's what this guy's deal is. Here's where he went. Let's talk about whether, there's a threat here. And at past employers, I've had non-compete provisions that we just make everyone sign, right? And we would always look at it case by case when somebody left. Is this something we want to pursue? And honestly, usually we didn't pursue it unless they broke the non-solicit as well and started trying to take customers away. But different people take different approaches to it, and that's got to be handled case by case. For you to give advice on that, you'd probably have to talk to somebody and see exactly what's going on.
It's very case and fact specific for sure, right? Because not every non-compete is drafted the same way. The language in all of these agreements, can be different. I mean, I get plenty of clients who come to me and say, this is the non-compete we've had in place for years, that is not a non-compete that I drafted. So we're trying to look at the provisions of the agreement, the situation involving the employee. Yeah, a lot of it's all very fact specific.
Yeah. So what's the timing on this? I mean, are we going to have an answer from the courts fairly soon? Is this thing being expedited? What's the deal?
The rule is supposed to actually go into effect September 4th, but there have already been some legal challenges. 3 lawsuits have been filed, 2 in Texas, 1 in Pennsylvania. And we've kind of got one of these cases in Texas that's sort of like on a fast track. And the court has already issued a scheduling order, kind of setting out a briefing schedule to deal with some of these issues. They're supposed to be having a hearing. And from what we hear right now, we think that the court should be issuing some sort of decision on this issue on July 3rd. So that's kind of the day that we're sort of watching and waiting, to see what happens, whether or not the court is going to issue a preliminary injunction to basically, enjoin enforcement of the rule, what's going to happen there. So we're hoping that we'll have some clarity at that point in time. So obviously, if the rule does go into effect, employers are going to need to know that to start, taking some steps and doing what they need to do to make sure they're in compliance, with the rule if it actually goes into effect.
Okay, so if I really want to bore my Fourth of July friends, right, I'll read this thing on the 3rd of July and tell them all about it the next day, right?
This is the epitome of freedom, guys. Read it.
Yeah, Independence Day, right? All right, so I hear this story a lot from interviewees. I interview a lot of people for jobs, and mostly salespeople in the logistics industry, to be honest with you. A lot of them have worked at a place that it's a freight brokerage out of Ohio, has a big office in Knoxville where I am as well. And basically everyone they hire has to sign a non-compete. But what their employees tell me a lot is they say, look, I didn't sign a non-compete. I don't know what you're talking about, right? And I say, well, show me the papers that you signed when you were onboarded as an employee. I don't care if you have to go back to them and ask them for them, right? Show me what you signed. And it turns out they did sign a non-compete. It's a lot of times it's young guys, fresh out of college or around that age. It's their first real job or something like that, right? And they didn't realize that they were getting into an industry where they had a future, and they kind of signed away their future to a particular company when they onboarded, is the way that they feel. And so I've interviewed a lot of these guys, and I basically tell them, look, come back in a year. I can't employ you until you've been out of the industry for a year, right? Because you've signed this non-compete, and the way I read it, it's enforceable, right? So what would you tell to employees who are just onboarding with an employer about that onboarding paperwork?
Well, I mean, look, as lawyers, we're obviously held to a different standard, right? So I mean, I think we probably drive our spouses and loved ones crazy because we read the fine print on everything before we sign our names. And I think there's a tendency, and look, I get it. There's a lot of onboarding paperwork when you start a new job. That's true of anyone. But obviously, in most states, if you signed it, you're deemed to have read it, right? So I think you just need to be careful and be sure that you're cognizant and that you understand what it is that you are agreeing to. If you're given an employment agreement, and you don't understand it, hire a lawyer, hire someone who can explain it to you to be sure you understand, what it is that, that you're agreeing to. I think, like I said, I think there's a lot of documents that employees sign on onboarding and they're not really paying attention to what they're doing. They're just signing whatever's put in front of them. But certainly if you have, any kind of employment agreement or restrictive covenant agreement, you need to be sure that you're reading that and that you understand, what you're agreeing to before you sign it. On the back end, though, I will say, that sometimes, there's room for negotiation and room for discussion with a previous employer, about whether or not they're willing to waive the non-compete restriction. I've had current clients that I've helped in that situation, right? They've said, we have this job opening, we have this person we'd really like to hire, but they have a non-compete agreement from a former employer, and we really want to hire them. And, I got in touch with the company, we had a discussion and figured out a way to work it out so that it was not a violation of the non-compete agreement, or they agreed to waive the provision for whatever reason. So I think there's always room, for some flexibility there. But I think you definitely, if you're on the employer side, you need to be careful. And what we say is don't hire a lawsuit, right? And what that means is you need to be asking the questions like you were just talking about, Alex. Are you under any current non-compete agreement? Are you sure? You need to maybe ask your former employer if you signed any kind of agreement like that, because we certainly don't want to bring you on and hire you and then find out our hiring of you is a violation of your non-compete agreement. And not only is your former employer going after you, the employee, they're coming after us as the company, because we've now tortiously interfered with the contract that you had with that company. So it can put the company in a bad position to hire somebody who's under one of those agreements.
Yeah. Yeah, and it's true. In my onboarding documents, I make every employee represent to me that they're not under one of these agreements, right? And so I want to be sure that that's not going to come back to bite me, and that you've put in writing that you're not aware of anything like that. Right. So, and then I guess this is one piece of legal advice I'll give. Nothing else on here is legal advice, but if you're going to sign something, read it first. That's legal advice. You can rely on it. Read it first. Do not sign anything without reading it and knowing what it says. And if you're not sure what the heck it is, don't sign it. But yeah. Thanks for joining me, Christy. Christy Rogers is an attorney and shareholder at Maynard Nexsen. She works in their Columbia, South Carolina office, where she focuses on employment law. Christy, I hope I do not need your services anytime soon, but let our listeners know, where can they find you if they need some information.
Yeah, so you can go to Maynard Nexsen's website and look me up, Christy Rogers, Rogers. I'm on the website. My email's there, my telephone's there, so you can easily reach out to me through the website. If you've got questions or you need a good lawyer, give me a call.